Hello students, welcome to the daily news analysis. I hope you all are doing good. I'm your educator Tirupura Singh. Let us begin with the important news articles of 7th February 2022. So as you can see on the screen, these are the important articles which we are going to study. Very important. The nation has mourns its nightingale. Tirupura, Brew people, Supreme Court weighing national security, and some other articles. Let us start with the first article. Students, the country is saddened and disheartened with the news which came yesterday, which blew us all. The nightingale, rightly called so, Swar Kokila Lata Mangeshkar, passed away at the age 92 in Mumbai. Now, as a student appearing for a competitive exam, one must have a knowledge about the important achievements, her contributions in the field of music and many awards that she won. Lata Mangeshkar, rightly so, is being referred as Nightingale or Swar Kokila, and she was born in Indore. However, she was from Maharashtra. And let us talk about her awards and recognitions. Students, in 1974, she became the first Indian to perform at the Royal Albert Hall. So this is a very important, I would say, achievement in her life. Performing in Royal Albert Hall is something wherein a person is showcasing his or her skills at the Royal Palace of England, right? So in this sense, she became the first Indian to perform at the Royal Albert Hall in England. She was also being bestowed or conferred with Dada Saheb Phalke Award in the year 1989, right? The highest award in film industry, Dada Saheb Phalke Award. Very, very important. She was an awardee of Bharat Ratna, India's highest civilian award, highest civilian honor in the year 2001. So she received it in the year 2001, the highest civilian honor, Bharat Ratna. Now, the French government also conferred her the award of Legion of Honor in the year 2007. So her life was definitely, she contributed immensely to the Indian film industry. Her voice, her music, her voice modulations were something which has no parallel, and that's the reason why she was the most loved among the loved daughter, and rightly so. Prime Minister Modi also referred her the daughter of the nation in the year 2019, and a new award was created, Daughter of the Nation Award 2019. Now, if I talk about her career, she sang almost 30,000 tracks in her lifetime, 30,000 songs, which is not an easy thing, right? And that is the reason, students, she was being included in Guinness record in the year 1974 itself. And by making a distinction of being the most recorded artist, right? So she was given Guinness record in 1974. At the same time, students, she also received 3 national film awards, and many other awards like Filmfare Best Female Playback Awards, so on and so forth, right? So students, the examiner might ask you questions on these lines: her contribution in Indian film industry, plus the awards and the honors that were conferred to Lata Mangeshkar. Rightly so, as they say that we just had once Lata Mangeshkar and we can never have any person of that stature. Any which ways, moving to the next news. Students, there have been a crisis of Tirupura Brew people. Now students, Brew, these are the people who were the indigenous of Mizoram. They are the tribal people, and they were basically the part of Mizoram. I mean, they are the indigenous people of Mizoram. right? And because the Brew people, who are the tribals originally from Mizoram, they are different, ethnically different from Mizo tribes. So I'm talking about the two tribes, students, Mizo tribes and the Brew tribes. Now Brew tribes majorly were living in the western Mizoram, right, this part. But they were ethnically different from the Mizo tribes. Their language was different, their cultural traditions were different, right? Their way of life was different, and therefore the Mizo tribes never, allowed the Brew tribes to merge into their society, right? So that is the reason why they were always discriminated. They were being oppressed and harassed by the Mizo tribes. Now, it happened that because of this oppression and harassment, one Brew tribe, he killed, some Mizo tribes, and this led to all the clashes and the riots in the state of Mizoram, a northeastern state. And post that, the Mizo tribes started, large scale riots against the Brew tribes. They started burning their villages, and they started inflicting all the atrocities against the Brew tribes, right? Now, because seeing this, they started fleeing their native state, and they started, settling in the nearby state of Tirupura. So students, you will find today Brew tribes temporarily residing in Tirupura. However, originally they were from Mizoram. Now, because of the clashes with the Mizo tribes, they had to leave their habitation, and they they moved, crossed the border of the state, and they moved to a new state, Tirupura, and they started settling there. Now, so the whole issue of Mizo tribe or the Brew tribe, Brew versus Mizo clashes, revolves around this idea. Now let us understand. Now here you have Mizoram, and from Mizoram they migrated to Tirupura, right? Now students, Brew tribes are also called as Ryang tribes. Very, very important. They are also called as Ryangs or Ryang tribes, and at present they are living in Tirupura in various relief camps, and they are at the tune of 30,000, right? However, students, there are some relief settlements being established by the government, but before we jump into that, we must understand the background. As I said, that Brews are ethnically different, distinct from the Mizos. They speak different language, right, that we already discussed. Now students, Brew and Ryang are a community indigenous to Mizoram basically, right? And in Tirupura, they are recognized as particularly vulnerable tribal group, right? And they have been targeted by the groups that do not consider them as indigenous. And following the ethnic clashes, around 37,000 Brews fled, to some districts in Tirupura, and therefore they are living in relief camps that I have just mentioned. Now students, although the agreement was being signed between the central government and the Brew tribes, only it happened in the month of January 2020, so it's a recent agreement, and I believe it can be asked in the examination. The Quadrilateral Agreement. Now the Quadrilateral Agreement means there are 4 parties: the central government, state government of Mizoram, and Tirupura. So we have come to 3, plus the Brew groups, right? So there are 4 parties, and they signed a mutual understanding between the government of Mizoram, Tirupura, Brew tribes, and the central government, right? And the central government said that we would, we would create some settlements, we would create some, relief camps for the Brew tribes living in Tirupura, right? As you can see, students, from the news article, where the government, after the Quadrilateral Agreement, says that 43% of around 7,000 families are living in some relief camps. So the government, as per their promise, have already set up the relief camps, and out of the total, Brew tribes, which were 30,000, right? Many have them being settled, and 43% of them are being given the relief camps, right? So government is, fulfilling its promise, and they have already, set up some relief camps in Tirupura. At the same time, government also promised that the rehabilitation package of rupees 4 lakh would be given, and land for constructing a house for each family, right? So for every family, a financial assistance of rupees 4 lakh plus land for constructing their house would be given, right? So this was the Quadrilateral Agreement. Now, what would happen? What made them flee to Tirupura? So what is the reason, which we all already discussed, students? About half the Brew population in Mizoram fled to Tirupura in the year 1997 following the ethnic clashes, because we know that the Brew and the Mizo tribes are ethnically different, right? Now the Brew leaders are demanded that the government should create a autonomous district council. Autonomous district council means those government, those I would say legislative structures where the Brew people have their say. That means some legislative structures where they can, put on their voice, or they can raise their voice. And this can be formed in Indian Constitution under 6th schedule, right? So autonomous district councils can be formed under 6th schedule of the Constitution, and they demanded that in the western area of Mizoram, which was their, indigenous land, their ADCs should be built up, right? Now, so they, the Dampa Tiger Reserve was also in the news, because one violent organization of Brew tribes called as Brew National Liberation Front, they kidnapped and they killed some one Mizo Forest Department official, right, who was working in Dampa Tiger Reserve, right? So the question may be asked about Dampa Tiger Reserve, right? And this actually led to all the clashes, right? Now the problem is that when the government has created some relief camps for Brew tribes in Tirupura, it may also result into some administrative challenges in the Tirupura state, right? They fear that many local Bengali non-tribal people would also start in conflict, would also enter into conflict with the Brew people, right? So therefore the whole issue about the Brew and the Mizo tribes, and how the quadrilateral dialogue actually paved the way for their settlement or relief camps in the state of Tirupura. I hope it is clear. Moving to the next news, student, as you can see on the screen, Supreme Court to weigh between national security and judicial scrutiny, right? Now students, there are two words here mentioned: national security, my bad, and judicial scrutiny. Now it has been in the news because the central government has been taking the exception from the judiciary. उस जुडिशरी से बचाव लेना चाह रहे हैं नेशनल सिक्योरिटी का हवाला देके, राइट? सो दे आर claiming that because this particular issue is concerns with the national security of the country, so therefore the judiciary must not intervene in that, right? See, we all know about a principle called as judicial review. Students, judiciary is the final interpreter of the constitution. It checks the legality of the laws passed by the legislature and any order issued by the executive, right? Now, and this power comes under the head or under its function called as judicial review, right? Now the government says that any issue which concerns the national security, the judiciary must not scrutinize that. There must be no judicial review over any confidential matter which is sensitive, which is important for the overall security of the nation, right? So in this sense, the government tries to, you know, take advantage of this clause of national security, but it is not so. We'll understand the cases in order to understand the debate. Now students, whether the state can use national security as a ground to limit judicial scrutiny, that is the question, right? Now the debate has arisen because of one case which is there called as Media One TV channel case. Media One TV channel case, right? Students, Media One TV is a media channel, is a TV channel or a news channel of Kerala, and this channel has been, you know, many times, multiple times, even in before, it has, you know, challenged the government's actions. It has accused the government's role in various riots like the Delhi riots and so on and so forth, right? So it tries to expose the government, right? You all know that in Kerala you have the leftist government, and therefore the central government, recently the Ministry of Information and Broadcasting has banned this TV channel. Media One TV channel was being banned by Ministry of Information and Broadcasting, right? Now, and it happened barely a few weeks after the Supreme Court order with regard to Pegasus case, because in Pegasus case the Supreme Court clearly said that center cannot expect a free pass from the courts as soon as it raises the specter of national security. That means सेंट्रल गवर्नमेंट को कोई फ्री पास नहीं मिल जाएगा जैसे ही आप नेशनल सिक्योरिटी का हवाला देखें. इट डजंट मीन दैट you can do anything and everything that you wish to do just by, you know, saying that certain matter relates to the national security of the country, right? So the Supreme Court has clearly said in Pegasus case, right? However, so I have given you the background of the issue. Now, in order to understand this, we must understand that we have a student in our Constitution, Article 19, Clause 1, Subclause A, which talks about freedom of speech and expression. Every individual has a right to freedom of speech and expression, right? So when you kill the media, when you kill the press, it is actually violation of Article 19, Clause 1, Subclause A, right? At the same time, we also have, in order to make you understand Article 19, let me share you a bit of detail about the same. Students, Article 19 is your right to freedom. And it has 6 rights under it. Article 19, Clause 1 says that every citizen has right to freedom of speech and expression, and the mnemonic that you can use to learn is SAM RP. So first is speech and expression. Second is freedom of association, freedom to assemble peacefully without arms. Third is freedom to form association or unions or cooperative societies. The word cooperative societies was being added by 97th Constitutional Amendment Act 2011. Earlier in the original constitution it was not there. Right? D talks about freedom of movement. E talks about freedom of residence, freedom to reside. And G, I am intentionally eliminating F. I'll give you the reason. Freedom of profession, occupation, trade and business. So students, these are the 6 rights which come under Article 19, which talks about right to freedom, right? So every citizen of the country has the right freedom of speech and expression. So therefore, if you kill media, which article you are violating, which clause you are violating? This one, 19 clause 1 subclause A, plus you are also violating 19 clause 1 subclause G, because media is a profession which disseminates information, right? So when you are killing media, when you are stopping any media by giving the excuse of national security, you are infringing Article 19 clause 1 subclause A plus Article 19 clause 1 subclause G, which talks about profession, occupation, trade and business, right? Now I said that I intentionally didn't mention F. Possibly students, you would be knowing that Article F originally talked about right to property, which was a fundamental right till 1978. So 44th Amendment Act of 1978 made it a legal right under Article 300A, right? So right to property is no more a fundamental right, it is being made a legal right by 44th Constitutional Amendment Act 1978. So Article 5 is gone, right? So there are 6 fundamental rights under Article 19, right? I hope it is clear. So students, when the government kills media, or when the government stops any media channel, it is actually taking away your Article 19 clause 1 subclause A and Article 19 clause 1 subclause G, right? But the government says that any activity which poses a threat on the security, sovereignty and integrity of the country, which is against the public interest, which is against the morality of the society, such activities can be restricted. So there is a restriction given under Article 19, right? Now, but this restriction has to be decided by the court and not the government, right? So now let us move back to our this thing again, our slide. So students, Media One TV channel was being stopped by the central government, and this is killing Article 19, which we have already discussed, right? So the government has to consider the chilling effect such state actions endure to have on free speech, especially in the media. Now we must understand the chilling effect, right? So the chilling effect is based on comparative harm. Let us understand how it works. Now students, in the Pegasus case, the government, the Chief Justice of India, N.V. Ramana, clearly said that it is a settled position of law that in matters pertaining to national security, the scope of judicial review is limited. That is well understood. But it does not mean that the state gets a free pass every time the specter of national security is raised, right? So the government must not use this card of national security each and every time it wants to, right? So it must be very properly utilized, right? It also says that there is no omnibus prohibition can be called for against judicial review, right? Now, in order to understand this, we must also understand the broader case in Supreme Court, Anuradha Bhasin case, or Anuradha Bhasin versus Union of India 2020. Students, you all know that post the reorganization of state of Jammu and Kashmir, some restrictions were being done on internet. So internet was banned for many months, right? So Anuradha Bhasin, who was one of the newspaper editor, she said that it is internet or access to internet is a part of is an integral part of Article 19, right, which is right to freedom. So therefore internet must not be restricted, right? So one possible test came, which was called as comparative harm. In this test, Supreme Court said that the test is whether action of the state on one entity freezes others' action in their footsteps, right? That means the restrictive effect on similarly placed individuals during the period. That means if the internet is being restricted, it should not be restricted only one particular person, but it should be, you know, violating the rights of a larger section of the society. Are you getting? That means any restriction on the fundamental right should not adversely affect a single individual, but it should be affecting the larger society, right? So that is called as comparative harm. So the comparative harm should be larger, then only you know, such restrictions, I mean such I would say infringement over the fundamental right should not happen, right? Otherwise, the banning of the internet, if government feels that it is against the security of the nation, it can do so if it is not fulfilling the test of comparative harm, right? But if it is, you know, harming the larger society, then definitely such restrictions must not be imposed, right? So in short, the test is whether action of the state on one entity freezes others in their footsteps or deters them from following the same course, right? Now, and so this is how the principle of chilling effect. Now it is a US concept which was also being taken up by Indian judiciary, right? Now even in America, the Supreme Court of America, SCOTUS, you know, said that the allegations of a subjective chill are not an adequate substitute for a claim of specific present objective harm or a threat of specific future harm. That means the harm should not be against any individual, but it should be against the larger society, right? So that test has to be made clear. Now the articles which are being infringed, as we have just discussed, students, Article 19 clause 1 subclause A, Article 19 clause 1 subclause G, right? And in this case, it was being, you know, accepted by Supreme Court that right to internet access is an integral part of the fundamental right under Article 19, right? So second, it also said that the internet suspension should take place only on those areas where there is absolute necessity, you know, or such restrictions are, you know, very much required. Otherwise, the government should not resort to, you know, any suspension of the internet. So only in those areas where there is absolute necessity of such restrictions, right? Now any order of the state which restricts the fundamental rights of speech or expression should be backed by reasons. So the government also has to give the reasons why they are, you know, blocking the internet, right? And the court should be convinced that the state acted in responsible manner, right? So these words, responsible manner, the government giving the reasons, only applying in those areas where it is absolutely necessary, right? So in this way, there are some restrictions which were being imposed over the government, right? The court should be convinced that the state acted in responsible manner and did not take away rights in an implied fashion or a casual or cavalier, right? So there should be a proper consideration of the case before the government, you know, takes away the right to internet. Similarly, students, a very important case again, Secretary, Ministry of Information and Broadcasting versus Cricket Association of Bengal and Shreya single case, right? So these are some very important cases where Supreme Court said that if the information which is being disseminated to a larger public or to a wider section of the population, you know, such dissemination should not be stopped and it is very much legible, right? So there is no dispute that freedom of speech and expression includes the right to disseminate information to as wide a section of the population as is possible. So there must be no, for example, the material that you get from the institute or your college or university, you start photocopying it, right? So when you are photocopying the material, the government or any claim should not be constituted against you, right? Because the dissemination of the information is also comes under the fundamental right of Article 19, right? And under Shreya's single case, the court made it very clear that every individual has the right to disseminate information to as wide as a section of population as is possible. The wider range of circulation of information or its greater impact cannot restrict the content, you know, the right, nor it can justify its denial. I hope it is clear. Now moving to a next case of Supreme Court, Fahima Shireen versus State of Kerala. Guys, these cases are being asked, they have been asked earlier in the examination, and they generally, the Clat authorities do ask these cases. So therefore you have to have a idea about these cases, right? So they'll ask, just put a name that Fahima Shireen versus State of Kerala talks about what. So it is right to internet under Article 21. So it gave a different interpretation of right to internet, where Anuradha Bhasin case said that right to internet is a integral part of Article 19, freedom of speech and expression. Here the court said that right to internet is an integral part of Article 21. We all know, student, Article 21 is right to life and liberty. The court said that internet is an integral part of today's present life, and if you snatch that right, it is an infringement of right to life and personal liberty, right? And here the court has adopted the United Nations Human Rights Council and General Assembly proclamation, which unequivocally said that, you know, internet access plays a key role in accessing information, and it's close linked to education and knowledge, right? So today, because post pandemic, we all know that internet has become very, very important. You are able to see me and I am able to reach you because of internet, right? Because of the advanced IT enabled services, technologies, right? So if I take away the right to internet, then, and because internet is very closely linked to the education and knowledge, so therefore it would be an infringement of right to life. We all know that right to education is also a fundamental right under Article 21A, which is under Article 21, which is right to life, right? So Article 21A, right to education, comes under right to life and personal liberty, right? So because internet has a very closely linked to education and knowledge, so therefore right to internet, you know, must not be taken away, and it is under Article 21 as held by the Supreme Court in Fahima Shireen versus State of Kerala 2019, right? Now in this sense, student, Kerala had become the first state in 2017 to declare access to internet a basic human right. So they may also ask you that which among the following states was the first to declare that access to internet is a basic human right. So it was Kerala government, right? I hope it is clear. Now moving to the next news, students, on the screen, Satkosia Tiger Reserve making fresh attempts to become a suitable tiger habitat. Now let us discuss about the tiger reserve. Now Satkosia Tiger Reserve is in the state of Odisha, right? Very important, it was in news, so they may ask you about the same, that Satkosia Tiger Reserve comes under which state. So it is the state of Odisha, right? And it has started all its efforts to re-establish itself as a tiger habitat, because its tiger population was dwindling. But now it is, the government is putting efforts to, you know, increase the tiger population in the STR or Satkosia Tiger Reserve. So Satkosia word actually derives from Hindi word Sat Kosia, right? So it is a area which is as of 2 miles, right? Now it is in 26, it is a wildlife sanctuary, and very importantly, it lies at Mahanadi River, near Mahanadi River, right? So there is a gorge near Mahanadi River, and over Mahanadi River, we all know, students, in peninsular India, you have a plateau called as Amarkantak Plateau. At MP. From Amarkantak Plateau, near Amarkantak Plateau, a river originates called as Mahanadi River. Towards east in Bay of Bengal. And you all know a dam is being built over it called Hirakud Dam. So just near Mahanadi River, a wildlife sanctuary is there called as Satkosia Wildlife Sanctuary. And it was been declared in the year 1976, right? And here you have all the tiger population. As you can see, a tiger reserve was being built at Satkosia, and so there is a picture from the Satkosia Tiger Reserve in Odisha, right? So the area was declared as Satkosia Tiger Reserve in the year 2007, and it comprised two adjoining wildlife sanctuaries, Satkosia Gorge Sanctuary and Baisi-Pali Sanctuary, right? So very important, there are two sanctuaries, which are being combined in this wildlife sanctuary. I mean, this tiger reserve, earlier it was a sanctuary and now it is being declared as a tiger reserve in 2007, and it comprises of two wildlife sanctuaries, Satkosia Gorge Sanctuary and Baisi-Pali Sanctuary, right? And it is also a part of Mahanadi Elephant Reserve, right? So Mahanadi Elephant Reserve is also there, and so therefore students, it's a very important area, and Satkosia Tiger Reserve may be asked in the examination. All right. So students, let us move to the editorial part of the Hindu, and we'll be discussing the important articles today. Now, in Karnataka, there is a district called as Udupi, very famous for its Krishna temple, right? And it is very much in the news. It has been very much in the news even in the past. Now, the temple of Udupi is world famous, in fact, and many cases, Supreme Court cases, have been based on Udupi, has been come from Udupi. Now, in Udupi, the Karnataka government has said that the Muslim girls won't be allowed to wear hijab, and if they wear hijab and enter in the college, they would be refused the entry, right? So this issue actually opens up a larger debate, right? The larger debate is whether essential religious practices which form the part of the religion, for example, let's say hijab, the scarf that the the Muslim women wear, right? So is it a part of essential religious practice? Yes, if it is a part of essential religious practice, then why the government is actually refusing their entry, right? So it has opened up a larger debate, because every religion has a right to maintain its own affairs, and this is right mentioned under Article 26 of the Constitution, right? So let us understand the issue. Now, Udupi, as I said, students, has always been in news right from the 16th century. It happened that a person, Kanak Das, from the so-called lower caste, he was being banned entering into the temple in 16th century, and he was not allowed to have a darshan of Lord Krishna. So what he did, he just sat outside the temple at one place and he started singing bhajans, for Lord Krishna, right? A miracle happened, students, that the deity of Krishna, miraculously turned 180 degrees to face west towards Kanak Das, and the wall that was actually there broke off, and a window was being formed, and therefore Kanak Das could have his darshan. And today also, students, if you go to Udupi, you will have the darshan of the Lord Krishna from the same window, also called as Kanak Das window. Now, it actually opens up various cases, right? That is the religion, any practice of the religion, is it authenticated by the court? Students, there have been many issues, because on one hand you have Article 25, which talks about right to freedom of religion. Every person has the right to propagate, profess his religion. On the other hand, you have Article 26, which talks about right to manage affairs of religion, subject to public health, morality, right? Subject to public order, health and morality. Now there is always conflict between these, right? Students, many practices in our country like Sabrimala issue, right? They said that Sabrimala is a part of our culture, it is a part of our religion, and it is being followed for many years. So therefore it has become a essential religious practice, and therefore they stopping the the women from the particular age, menstruating women, not allowed into the temple, right? So still the case is sub judice in Supreme Court. Similarly, the female genital mutation, female genital mutilation by in the Bohra community, right? So the female genital mutilation in the Bohra community is also, they say that it is a part of an essential religious practice, right? But then it is again harming the right, Article 15. It is again in conflict with Article 15 and Article 14, which is right to equality, right? There are many other students' religious practices which are still sub judice under the Supreme Court, and the court is actually deliberating that which way we should go, right? Because you have Article 14 which talks about right to equality, you have Article 15 which talks about prohibition of discrimination based on religion, race, caste, sex and place of origin. At the same time, you have many practices like Sabrimala, female genital mutilation in Bohra community, which they claim come under Article 26, right? So there is a conflict between these articles, and understanding this conflict, many cases emerged in the Supreme Court, right? The first such case was in the year 1954, just after independence, Madras versus Sri Lakshmindra Tirtha Swaminayar, or of Sri Mutt case. It is also referred as Shirur Mutt case or Shirur Mutt case of 1954. In this case, students, the court clearly ruled that what constitutes the essential part of a religion is primarily to be ascertained with reference to the doctrine of that religion itself. That means what practice would be a part of essential, what practice would be called as essential religious practice would be decided by that religion itself, right? In this sense, the ball has gone to the religion, right? So it was a very dangerous decision, but then it was later reviewed, and the court said that the essential religious practices, and many other judgments came over the religious practice, and they said that since it was first propounded that essential religious practice test has been problematic, because how you will decide what is essential and what is non-essential. So it is a very big problem to decide what is essential and what is non-essential. For example, in Sikh religion, Sardars can carry kirpans, right? So carrying kirpan is an essential part of their religion, and they do not harm the society. They do not create a threat in the society, right? It is a part of their, it is an integral part of their religion. It is an essential practice of their religion, right? And it is not harming the public order, health and morality. So it is very much allowed, right? So therefore the many cases are saying that what is essential and what is non-essential, how you will decide. So many cases came with the Supreme Court. So for example, if you talk about, if you say that hijab is an essential part or a non-essential part, then you are actually talking about the larger question, which is question of uniform. That means, although definitely in the schools and colleges there is uniform, but if we allow this to happen, then the government of Karnataka may come up with a standard uniform which has to be followed across the state, right? Which would be very different, which would be very dangerous, right, and detrimental. So the many questions have emerged in this article. Can government colleges deny education to students who are seen to be violating a uniform code, right? So this is also a very important question, because education is again a fundamental right under Article 21. Is the hijab or even a full covering in any manner violative of the process of imparting education? Or can a government commitment to female education deny education to those it deems improperly dressed, right? So many questions have been explored over this issue, and we have just, students, on the screen you can see Article 25 Clause 2 Subclause B, which talks about freedom of conscience and free profession, practice and propagation of religion, right? And they have also mentioned in explanation that wearing and carrying of kirpans shall be deemed to be included in the profession of Sikh religion, right? At the same time, Article 26B talks about freedom to manage religious affairs subject to public order, morality and health, right? That means every citizen has freedom to manage his or her religious affairs, but it must not, go against the public order, morality and health. And every religious domination or any section thereof shall have the right to manage its own affairs in matters of religion, right? So they always give the Article 20, they give the power of Article 26B for the practices that are being carried in various religions, right? Students, even in Hindu religion, untouchability was a practice being followed in Hinduism, and many of its supporters gave the the support of Article 26 Clause B, that it is a essential practice and it is an part of an integral part of the religion. But court clearly said and made a fundamental right, even in the original constitution under Article 17 they abolished untouchability, saying that untouchability is against the ideals and tenets of the constitution. So therefore any such practice of religion which goes against the ideals of the constitution must be abolished, right? So students, in India we have a positive secularism. We follow positive secularism. State do not have any official religion, but state maintains a principled distance, a principled distance vis-a-vis religion. That means the state won't interfere in your religion until and unless it finds that any practice of your religion is against the ideals of the constitution, right? So in this way, students, the state maintains a principled distance vis-a-vis religion, right? So this concept is called as positive secularism, right? So many cases like Shirur Tat Mutt in 1957, in Sri Venkataraman Devaru versus State of Mysore, the exclusion of a person from entering into a temple for worship is a matter of religion according to Hindu ceremonial law, right? The court held that whenever such conflicts are there between Article 25 and Article 26, Article 26 Clause B must yield to the overriding right. The overriding right declared in Article 25 Clause 2 Clause B, right? So the court has given an overriding power of Article, to Article 25 Clause 2, so it always will be having an overriding power, and any practice of the religion must pass the test of reasonability and must pass the test as defined by the constitution, right? So even students, American scholar John Higg, also called as Higgins Bhagavatar, he also was very much fond of Udupi Sri Krishna, and he was also denied entry into the temple because of his white skin, right? But he started chanting the bhajans, and the priest there, fearing that again the ideal would move in that direction and some curse would happen, they offered him the worship and the darshana, right? So this is how, students, this issue is very much there in the news, and today we have discussed some important articles by the understanding of the the articles which came in the news. We talked about Article 19 in detail. Also we discussed Article 25, 26 and how they are in conflict, and how the test of reasonability is being applied by the Supreme Court. I hope you enjoyed the session, students, and that's all for today. Wish you all the best. See you in the next class. Good day. Goodbye.